Now at this point, surely one of the biggest influences on the continued increase in witch trials in England and indeed in Scotland was the coming to the throne of James I. Now James I, who of course replaced Elizabeth as the king of both England and Scotland, he had become very interested, some would say obsessed, with the issue of witchcraft several years earlier when he was still the king of Scotland. In 1590, he'd been on a boat, he'd been on a sailing trip, essentially coming home from his wedding in Norway with Anne of Denmark, and his ship had been capsized, his ship had been wrecked, and after taking advice from various people, he came to the view that his ship had been wrecked due to witchcraft. And he believed that a gang or a coven of at least 100 witches had conspired to destroy his boat in this way. And so really remarkably, for the next 2 years, between 1590 and 1592, James effectively presided himself directly over the trial of about 100 alleged witches. Many of them ended up being hanged. Following that, he'd written a book on the subject of witchcraft, and in particular laying out his own ideas about the law and his own ideas about the procedure one needed to follow in order to successfully try a witch. That book was called Demonology. And Demonology ultimately came to really influence the passing of another law after James became king of the new united England and Scotland. So the Witchcraft Act of 1604 was based largely on James's book Demonology. Again, interestingly, to some extent, it was an act steeped in procedural safeguards. One interesting aspect of it is that effectively, even though James was, as I say, very concerned about witchcraft, prosecutions for the crime actually went down after 1604, and that was principally because the Act had specifically prohibited torture as a means of getting confessions from witches. So although, if you like, the Act was more definitive in the way witches should be dealt with and should be tried, actually it did deny the prosecutors the opportunity to essentially torture confessions out of them. So you had fewer confessions and therefore actually fewer convictions. Nevertheless, what the Act did do was effectively give a mandate to the authorities in both England and equivalently in Scotland to pursue witches as a kind of a mainstream activity and a mainstream part, if you like, of the criminal justice system. And it is that really after 1604 that led to some of the most famous witch trials in English history. Probably the most famous being the Pendel Witches, who were tried in 1612. Many of them apparently actually believed they did have supernatural powers, and so at least some of them pleaded guilty to witchcraft, believing that they indeed were witches. But from a legal perspective, what's quite interesting about the Pendel Witch trials is that they were convicted largely based on the testimony of one person, and that was a 9-year-old girl. And the reason that's so interesting is that actually children were not allowed to give evidence for the purposes of most criminal trials at the time, because it was felt that children could not be trusted to give, accurate evidence. And indeed, that persevered right up until the 20th century. It's a relatively new phenomenon of allowing and accepting child evidence in criminal courts. Another big aspect of that was the acceptance and the use of so-called spectral evidence. Quite often, perhaps unsurprisingly, witnesses were not available to attest that they had seen actual witchcraft occurring. But what would be accepted by these courts was so-called spectral evidence, which essentially was evidence of dreams and visions, because the belief was that witches could visit you in your sleep and sort of affect you whilst you were dreaming. And so people would come forward, and a lot of this evidence was of things that people had alleged to have seen in their dreams, and it would be things like the alleged witch coming into the house and doing nasty things to children and so on.